Hey guys, let's get ahead of the media and take a look at likely appeal angles for Manson and how the court will consider them. Let's go over first, what will be appealed? Second, how does an appeal work? Third, what standard does Manson have to meet to win an appeal? And fourth, what are the likely appeal grounds? First, what will get appealed? The judge finally ruled on the motion by Wood and Gore to strike speech-related allegations and granted almost all of what they wanted. This puts big holes in Manson's case. Aside from a few contentions that were not struck, it basically leaves the alleged swatting, hacking, and online impersonation at issue, the rest gone. Everybody on both sides probably agrees this is way short of what Manson was originally suing over. These got struck because of the anti-SLAPP law, and the laws are meant to prevent well-heeled people from using courts as an expensive hammer to beat people into not speaking up about issues important to public dialogue. It's not meant to insulate people from tortious speech, but rather to provide a way by motion to test a case early and before large expense has been incurred to see whether the suit is based on claims that have merit or they're just filed to harass a defendant for speaking up. That's the ideal, right? Does it work? Probably sometimes, but it doesn't appear quick or cheap in California at least, and particularly in this Manson case. It's been going on forever, right? Also, since the legislature made it immediately appealable by whichever side loses, even if the motion were held quickly and before lots of money got spent, when the appeal happens, that's going to be slow and expensive itself. So slow and expensive once or slow and expensive twice, whatever. Anyway, the final point is that not only does this ruling really reduce the scope of Manson's case, he's also going to be taxed with the defendant's attorney's fees, and that amount will probably be interesting. If you think that's an unfair burden, remember how many times you hear people say, if people suffered consequences for all these bogus lawsuits, there wouldn't be so much crap in the courts. Well, that's the thought that's in action here, taxing cost. That's an exception to the normal American way of doing litigation, but there are more exceptions to that than ever. Sometimes these things sound better in principle than when it's actually your ox being gored, no pun intended. So Manson has two good reasons to appeal. First, to regain the scope of his lawsuit, and second, to avoid paying defendants for the pleasure of successfully opposing his claims. And it's really his only option for relief. Since an anti-SLAPP motion is considered a judgment on the merits, it should be subject to res judicata, and that prevents relitigating items already the subject of a judgment. So it's not like he can just dismiss this lawsuit because he doesn't like how it went and file a new one. His option is either to take the L or appeal. Now his attorneys say they'll appeal, which is sensible. So when this gets appealed, that will, I can say with confidence, stay the remainder of the case. So the things that are still sitting out there, the court's not going to go ahead with those. And a stay is not automatically appropriate in every appeal, in every situation. But because Manson's allegations are, reasonably joined in a narrative that the defendants were out to injure him, I think everybody can agree that's what he's trying to say, it would make no sense to move forward on the remaining claims while half or more of the suit is on appeal. So the case at the trial level will halt while the appeal is pending. All right, what is an appeal? Appeals are not like new trials. The Court of Appeal doesn't swear in witnesses and act as a fresh new trial. They hardly even do any oral argument or hearings, right? It's mostly paperwork. What they look for are legal errors at the trial court level, generally. The person appealing, the appellant, is saying the judge made a material legal error. So the Court of Appeals expects the appellant to show what the judge's mistake was based on the record that exists and why it amounts to reversible error. Let's take two easy examples. The trial court dismisses the case right at the beginning saying, I haven't heard anything that makes me think your case will be proven at the end of this, so let's just cut the crap now, dismissed. If the court is making judgments about the weight of the evidence before discovery and even before a motion for summary judgment is made, that would be a material legal error because it does not follow the laws and rules of when and how to judge a case. Maybe a judge lets in salacious hearsay evidence saying, I know this is hearsay, but it's really too interesting for the jury not to hear it. I want to hear it. So objection overruled. That would too, potentially, obviously, be outside the bounds of the rules of evidence and an error, probably, potentially, a material error. So let's go the other way. A jury reaches a verdict and you think they were wrong. Must have been a dumb jury. Those can happen. So you appeal and ask the Court of Appeals to review this case. and see if they agree with this dumb jury. Nobody else would think this was right? It just was a bunch of idiots. Well, you lose. The court is looking for legal error. Generally, the court's not going to sit up there and weigh witness credibility and turn themselves into a new jury and see whose case is better. Instead, unless you can just show there was no evidence, they're going to say, we don't second guess fact finding, bro, and send you home a 2-time loser. So from this, you might now understand why it's generally a losing proposition to say, hey, we found some new evidence the Court of Appeals can look at. We forgot to ask this question or something like that. Nope. If you didn't get your evidence to the trial court when that court was making the decision, it's on you. You don't get to relitigate cases over time as you discover this and that like an Easter egg hunt. You need to fill your whole basket up before you come in the first time. So be ready when the case is active. Obviously, there can be an exception for this for people in jail, criminal cases, due process, and we don't want innocent people sitting in jail. But even that has hurdles. On civil cases, to quote racers, you run with what you brung. Now, that's different than if you tried to introduce evidence and the trial court didn't allow it. That's a legal ruling, and it's subject potentially to appeal. Manson will definitely be making this point, I think, as we will look at. All right, well, how are our appeals? 1, you tell the Court of Appeals, hey, the trial court made, say, 3 errors, and those are called assignments of error. So 3 assignments of error, and they rise to the level of warranting a reversal. You don't talk about trivial non-material errors. Of course, they're not going to throw out an order or verdict over something that's trivial, so these need to be significant things that would change the case. The Court of Appeals will look at those assignments of error and consider them in light of what they view as the appropriate standard of review. Not every type of error gets considered in light of the same scrutiny. For example, in court, based on the type of case, burdens of proof can range from either just more likely than not, say in a car crash, to clear and convincing in some types of intentional torts, to beyond a reasonable doubt in criminal cases. So the type of case determines the burden of proof that's going to be required. So this is a similar thought on the appellate level, that the type of action the trial court was taking will largely determine what the standard of review will be, whether it gets more or less scrutiny. There are various standards of review, but I think there's only going to be 2 here that will play into this case. I could be surprised. The first is de novo review. A de novo review generally shows no deference to the trial court. It essentially is a fresh look at the issue, not the whole case, but the issue. This is generally when the error is in the nature of being a mistake of the law, because the Court of Appeals will look at that fresh. There's nobody judging witnesses on mistakes of law. That's just an application of the law. So let's say the judge said, hey, the statute of limitations is 3 years, but it's really 2 years. The Court of Appeals itself will just look at the law and say whether that ruling was correct. They don't have to say, I'm not going to read it. I'll just trust the trial court. So on an error of law, they'll look at it fresh. And because it's a legal conclusion, they just don't defer to the trial court. It's very good news for Manson here, because anti-SLAPP rulings, being based on legal conclusions and not the weighing of evidence, are reviewed de novo. It's kind of the best case for him for an appeal. They get a fresh look at certain issues. So that means for the legal points of error Manson will allege, he gets them to look at it without deferring to the trial court. So if you don't like this judge and you think another judge will look at it differently, that's good news, because they don't have to say, well, she made the decision, we're just going to let it stand. They will look at the legal issues fresh. Now, the bad news for Manson is that matters outside of the anti-SLAPP ruling, such as whether to allow filings after deadlines like the Smith-Line Declaration or the scope of the discovery lift, because the SLAPP statute generally stays all discovery, depending on whether the judge wants to allow some based on good cause shown. These type of things, as far as I know, are likely going to be reviewed under the abuse of discretion standard. Now, discretion means, of course, the trial level judge has a latitude of what to do. That's what discretion is all about. The Court of Appeals won't reverse here, even if they, like me, would have decided differently than this trial level judge on some of this discovery stuff. They will only reverse it if the discretion is abused. That's a tough standard, right? Abuse of discretion, and it should be. But there are 2 angles here that if you can show the decision was based on, say, a legal mistake, that can be shown as a form of abuse of discretion. If the judge is wrong on the law, it's not really discretion, right? So that would be abusing this concept of making an informed judgment within latitude if it's legally wrong. Also, if I were him, I'd argue that not allowing limited additional evidence, that's no real extra burden to the defendants, that could materially alter the later anti-SLAPP ruling that's to come, that's a substantial injustice if claims with merit are kicked out due to technical deadlines. Now, that's not any kind of slam dunk argument, but that's a way. Those are two ways to maybe get the camel's nose under the tent, and we'll look at them more closely as they apply. All right, you are now a certified expert on cases at the appellate level. Let's get to the meat of this. Certified crazy, maybe. Manson will likely have two buckets of things to talk about. Bucket one are the evidence rulings, the input into the judge's decision. Manson here, I think, for example, would argue the Gore deposition scope was too limited, that just allowing us to talk about her state of mind when she was already under oath is too limited. We should have been able to ask about the letter, for example. He's obviously going to argue, and said he will, that the Smith-Line Declaration should have been allowed, that in the interest of justice, that he needed to be able to present this evidence. He's also going to say that the judge refused to take on board iPad evidence of how the FBI letter was created and its impact on the case, and maybe some other things too, but discovery type of evidence. I could be wrong, but I think this bucket, at least on the deposition and the Smith-Line Declaration angles, will be reviewed based on abuse of discretion, because these are kind of procedural things. They're not conclusions, they're procedural items. This is a tough one because on the deposition, the default state once a SLAPP motion or anti-SLAPP motion is filed is that there'll be no discovery, though the judge may, the statute says may, allow discovery based on good cause shown by the plaintiff. The corollary of may is may not. If the statute said discovery will be allowed on good cause shown, Manson's argument would be pretty strong, or stronger at least. So Manson's attorneys will look for cases that read towards saying discovery should be or must be allowed if good cause is shown. We'll have to see if they find any. I don't know of it. And then they'd have to convince the Court of Appeals that may means at least almost shall, and that the judge was wrong to not find good cause shown for broader discovery. It's not impossible, but doesn't that sound unlikely just on the face of it? We'd have to see the research briefs by Manson and the defendants to handicap this accurately, but I don't really like the odds of this at first glance. On the Smith-Line Declaration, did the judge abuse her discretion by not allowing filings post-deadline? It clearly wasn't Manson's fault he didn't have this evidence earlier. He wasn't setting on it. Smith-Line had dodged a deposition in another case, and Manson wasn't allowed to notice her deposition in this case. Plus, she had a case against him. So until she did a 180 or 360 and then a 180, I don't know, whatever. She definitely reversed course eventually. He couldn't have gotten any of this information. On the other hand, there are deadlines and judges need to move on with cases. And if everyone could appeal missing deadlines and win, then overall the court system would get even messier. On the other hand, should a motion deadline prevent material evidence from being considered when it's just one thing and the tardiness was certainly not the fault of the tendering party? Isn't that kind of technicality and injustice? There are California cases saying where possible cases should be decided on merit and not technical defaults. Can Manson find one like that straight on for SLAPP cases? I don't know. My sense is the odds are not great here, but better than the deposition argument. Of course, remember, I'm not being paid to spend days researching this, so any thoughts on the odds of this stuff, it's entirely subject to seeing the briefs the parties present when they do canvass all this stuff. Until we know their actual arguments and the authorities they cite, we're doing a lot of not fully informed speculation. I would have allowed Smith-Line's declaration in this case because of the circumstances personally, but my different perspective there does not mean I think this was legal error. We'll just have to see. Bucket two is the ruling itself. Now here, under de novo review, the judge is either right or wrong. Discretion is not part of this, I think. No deference is warranted. So let's take a look at the central contentions, not necessarily in order. First, the intentional infliction of emotional distress claim. I will try to quote Manson's lawsuit because if you just start paraphrasing it, you're walking away from the Court of Appeals is going to actually consider, because they're going to look at this lawsuit and then what comes under it. They won't think about theories and stuff like that. They need to look at what was alleged. So let's start with the recruiting. Manson says in his IIED claim that part of the outrageous acts, I think he lists 5 things. One of them is the defendants were recruiting, coordinating, and pressuring multiple women to make false accusations against Warner and to be part of their film project. Now, you aren't just looking at the suit to see, well, did they do those things? Because this is a claim for intentional infliction of emotional distress, that act has to be extreme and outrageous, beyond the bounds of a civilized society. Not just true, it has to meet this high level of being ridiculously outrageous so that intentional infliction of emotional distress does become a catch-all tort that can be alleged for anything. So in order to just keep it from being a general butthurt tort, you have this high hurdle that the act has to be extremely outrageous. So there are statements on the record that could be viewed, I think, as recruiting and in coordinating and maybe pressuring, although I think that's a stretch. Sorry, let's just keep it real here. But the judge said the evidence on the record of Wood and Gore's statements were not beyond the bounds of civilized society in terms of pressuring them to make false allegations. Instead, in some cases, they're told, hey, you don't even have to speak if you don't want to, or you can just listen. And so I think the judge is correct here. I'm not disputing a pro-Manson person's view that this was part of a scheme, say, to damage Manson. That could be true or not true. What I am saying here is the judge is looking at these statements as Manson listed them in his IIED claim and saying that these statements to get women to participate are not the kind of thing that's extremely outrageous. They weren't threatened or blackmailed or something like this. They were invited to some degree to participate or not. So that's not a judgment about what the defendants did in other respects, as I just said. It's just this one contention. Now, the Smith-Line Declaration, it could have changed that to some degree. Manson would have to win on that being allowed in, that the judge holding it out was error, and we already covered that, so that's subject of something else. Now let's go to the FBI letter, which I think gets most of the attention. Manson said the defendants were falsifying correspondence from a fictitious federal agent claiming that there was concern for the safety of Wood, other alleged victims of Warner, and their families, as well as an ongoing federal criminal investigation targeting Warner. Was that letter fake? In my opinion, yes. I mean, pretty clearly, in my opinion. Even Wood has walked away from it in her most recent declaration. To a reasonable reader, would one think it was meant to have originated from some federal agent, which it appears this agency doesn't exist and this person didn't write it? Yeah, I think that's fair. So to me, whatever the final facts may be, Manson has at least alleged with some evidence that the defendant's involvement in the creation and use of this letter could be found to exist, and that the letter is the things that he says it is in terms of not being real and all that stuff, and potentially illegal, right? However, let's keep it back to this appeal. He's using it as a contention for intentional infliction of emotional distress. He's not just out there saying, look at this bad letter. Why won't anyone agree with me whether it's bad or not? That's not the test here. The test is for this cause of action. And that's the problem. The evidence of the publication of this letter was in the context of the custody dispute. That, I think the judge correctly says, comes under, initially at least, the litigation privilege. Now, that privilege might be reduced if the activity were shown to be illegal, but for purposes of SLAPP suits, that's only considered if the defendant admits the illegality, or if they don't do that, it's not controverted. If there's a controversy over whether it's illegal or not, in other words, the defendant disputes it, and they have some evidence of that, then you don't decide who's right or wrong, but you can't use the illegality to pull it out from the statute. And of course, Wood filed a declaration controverting that. She says, hey, I didn't do this. I didn't know it was fake or whatever at the time I got this thing. Now, whether you believe her or not, it's not the point. The point is that she has disputed his version of it. So what that does, the effect of that is not to say, well, she can just do whatever she wants. What the effect of it is to say that it stays within prong one of this SLAPP test, which is it covered under this motion and subject to saying whether it supports the merits of Manson's claim. That's what you're getting out of this so far. So according to the case law as explained by the judge, and when I looked at it, I think she's right. That's enough to keep the litigation privilege in place for purposes of this motion. It doesn't control what the judge in that other case could do. It doesn't control what law enforcement could do about this, right? This is just for this SLAPP motion and for this intentional infliction of emotional distress claim. So this was Manson's main argument to try and win on the prong one. Is this within the scope of this motion? And he didn't succeed there, but I think he makes another argument, which is this is also just context for the overall suit. But in my humble opinion, this doesn't win because it's not listed in the factual allegations as just context. It's a specific item in his IIED claim. It's listed there as one of the 5 things. So I don't think it's just context. I think it is an element. But I hear what he's saying. It certainly is context for everything that's going on and for why there could be credibility issues with the defendants, but it is also listed as an element, supporting element within his actual claim. And that makes a difference for this kind of thing. Now, this whole thing on this prong one, is it within the scope? It's a little bizarre to me because the defendant seemed to have threaded a needle here. Only Wood moved to strike the letter, not Gore, right? And it's really only her behavior and acts then that are being tested in relation to it. And Gore didn't have to answer or argue about this letter and talk about it in the deposition. Manson couldn't ask about it. Wood's last declaration says, I didn't make this letter or know it was false. That leaves a pretty big question to, well, who did do it then, right? Maybe not the biggest mystery on the planet for a lot of people watching this case to think they already know the answer to that. My thought is, if Gore didn't move to strike the letter and didn't have to contest its illegality as Wood did, and say, look, I didn't do it or whatever, she didn't have to say that. How can she piggyback off of Wood's effort here and have those allegations struck as it relates to her, not just Wood? That's pretty good lawyering on the defendant's part. Anyway, the judge found the letter used in the child custody case was covered by the statute. In other words, she can assess it. That doesn't mean by itself it's immune. Now the analysis proceeds to whether Manson could win an intentional infliction of emotional distress case based on this letter, because that's where he cited it. The big problem here is that the letter was not shown by the evidence in the record to have been published by defendants outside the litigation. It's only published inside the litigation, and the judge says there's a privilege there, and that means it's not actionable. You can't bring an IIED claim based on what's inside the litigation or litigation. The letter in the context of this IIED claim must have caused Manson emotional distress through the defendant's use of it outside of litigation. Now, whether it shows they were doing bad things, or the letter's really bad, or it's illegal, or it's false, all those things that people can think about it, I get why all that matters, and I get why it's context to the case. I'd want it in too. But what is at issue here is whether the letter was used to cause emotional distress outside the custody litigation. And the judge says there's no evidence on the record of that, and because of that, the judge struck it. So you either have to say she missed the evidence in the record, and I didn't see it either, or you have to go with the context argument. But since it's cited not just as context in the facts narrative, but rather as one of the 5 specific things that caused emotional distress, I don't see that winning. The third emotional distress contention at issue, and the one that's also stated separately as defamation, is the defendants making knowingly false and defamatory statements against Warner, including that the actress in the groupie video was a minor and that the Warner was making, I won't say these words because I don't think YouTube doesn't want you to say it or not, but you know what they accused him of making, abusing a minor. The complaint alleges that Gore said this, so let's start there. The issue became whether she had actual malice under the law when making these statements about Manson. Because Manson is a public figure, mere negligence is not enough, but rather he needs to show Gore acted with actual malice. And actual malice doesn't have the plain meaning that you might think it does, or that I thought it did. What it really means here is the person making this statement either knew the statement was false or did it with reckless indifference. To wit, the person had serious doubts about the truth of the statement, but made it anyway. It's a very uphill battle to say the person should have checked more. It's really about the serious doubt angle. And I think Gore did enough in her depo to avoid someone reading it and saying, yeah, she didn't really believe what she was saying about this film, or she really thought it was false, but she said it anyway. And I think some of the criticism people have made in comments that how can you really get good evidence of somebody's subjective state of mind if they don't want to disclose it? It's a very valid point. That point notwithstanding, that is the legal standard. And so I think odds are against Manson here. As to Wood, Manson seeks to link her in via a civil conspiracy claim on these statements about the groupie video. Now, the conspiracy claim is not a conspiracy in the sense of cable news or Twitter. It's a way to have vicarious liability. In other words, a defendant having joint liability for the acts of another defendant. And what would cause that? Well, that requires that you show that the defendants acted in concert with a mutual understanding to accomplish a common and unlawful plan. Not aliens or something like that. It's really this simple. And at least one of them did something to further the plan that's actionable. So if two people go, yeah, let's get this guy, and they have an understanding they're going to do something potentially unlawful to do it, one of them doesn't, they're both liable. But here the judge said there was no evidence Wood knew about Gore wanting to make any false statements about Groupie as part of a plan. Again, whether true or false, that's to be decided later in the case if it matters at all. The point here are the allegations and evidence of Wood's mindset here. Now, since the judge tossed the claim saying there wasn't actual malice, also taking Wood out of this on saying there was no common plan between Wood and Gore, to me is a bit of overkill there. I mean, Manson's whole lawsuit starts off saying they had a common scheme and plan, and they were tied tightly together, I think, through factual allegations of the complaint. So my issue with the judge's reasoning here is that if there were a common plan to damage Manson between Gore and Wood, and if they had an understanding it could be accomplished by acts lawful or tortious, then do they have to know about every single thing each other is doing to have vicarious liability? And you have to show that right away in the first part of the case? I don't agree with that. Maybe it's the anti-SLAPP focus that you have to show it for this particular item that is being struck, the groupie statements, and not just in general. And if that's the reasoning, I get it. I still don't necessarily agree with it. If I were going to dump Wood here, I'd back it up some and say there's no evidence Wood agreed to the tortious means to damage Manson. Because I don't know that you have to agree with each thing each person's going to do as long as it's within what you'd reasonably expect a co-conspirator to do. But either way, if the court says there was no actual malice and this isn't actionable to begin with, I don't know that it matters a whole lot. It might matter later in the case if the thing ever keeps going forever. If this judge is this skeptical of civil conspiracy claims, that's certainly good for Wood, because even the remaining items, you know, the impersonation and swatting and online hacking and stuff, are alleged to have been done by Gore, and Wood only connected, if she is, by a civil conspiracy. So if the judge doesn't see that here, it's really good news for Wood in the future as well. Now, there will also be arguments about the allegations being struck generally in the complaint rather than left in to provide context to other claims. I think this is subordinate to what we already discussed. If the allegations were rightfully struck as a basis for cause of action, then it seems right to me to strike them altogether. If they had not been made the basis for cause of action, but were only context from the start, then I think it would be unfair to strike them as context. That would be different. To do otherwise, it seems to me, would allow a plaintiff who loses on the anti-SLAPP, when they have it as a part of a cause of action and you get blown out by the judge, but then you say you want to keep it in its context, you're kind of still contending on allegations that the judge said are out of this case, and that would gut to some degree the point of the law. So I think the real winning and losing comes in what we discussed earlier as elements of the cause of action, the actual allegations used in the cause of action. And if they get blown out there, they're probably not going to be allowed in somewhere else. That's my opinion. So from all of this, I think the record as the judge had it provides a logical basis for her ruling, which certainly could have been different. And certainly I would have made different rulings along the way, and you might have made tighter or looser ones. Who knows? That to me makes it critical, though, that Manson succeed in his argument that crucial evidence was not considered. And his attorney, I think, when he made his comments to Deadline, said, look, we think some critical evidence was not put in front of the judge for her to consider. She declined to have it, such as, say, the Smithline Declaration as a principal one, that if she had evaluated that, she wouldn't have found the same conclusions that she did. Well, that's a big argument, and I think it is a critical one because it could have changed the result. Well, that's appeals in general and a forecast of the upcoming battle here with not a lot of information for us to really look at yet, all in a very large nutshell. And that's it. Thanks, bye.